Hi, my name is Lee Lockett, and I'd like to talk to you today about Florida's ever-changing laws when it comes to marijuana possession. As you may have heard, Florida back in 2017 passed a law regarding medicinal marijuana. It has forever changed the way that the marijuana statutes read and has impacted the way that police officers in the field investigate marijuana possession cases, as well as the way that prosecutors will prosecute these cases. In addition to the medicinal marijuana laws, Florida has also legalized hemp, and we'll talk about the importance of that, as well as possible defenses to marijuana possession charges, as well as the possible sentencing ranges one could face if convicted of either a misdemeanor or felony level marijuana possession charge. In 2017, Florida passed a medical marijuana bill that now allows persons to lawfully possess and to use marijuana. Although you cannot smoke the medicinal marijuana in your car or in public, you can possess it and use it in its lawfully prescribed way. That has created, though, somewhat of a challenge for police officers in the field, because unless they do their due diligence and conduct the investigation in the appropriate way, legal challenges to the lawfulness of the search and of the arrest could be challenged and advanced in court. For example, if before searching a vehicle, an officer does not first find out whether or not the driver or the occupants are medical marijuana patients and are lawfully possessing the marijuana, then a search of the car without consent or without a warrant could be deemed later in court as being unlawful, and therefore successful motions to suppress could be filed. In addition to the medical marijuana statutes, Florida has also passed a hemp law that has legalized hemp, which has also further created some challenges in the field for law enforcement, as well as prosecutors in court in successfully prosecuting these cases. That's largely because of the confusion over what hemp is and what marijuana is. There's a lot of disagreement on the streets about what that is, but it's important to understand that there are stark differences between the two, but there are also some very noticeable similarities. It's important to understand what hemp is and what marijuana is. While they both are plants that fall under the cannabis genus of a species of the same plant, cannabis, marijuana is a plant that has a THC concentration anywhere between 5 to 30%. THC is the psychoactive intoxicating compound in marijuana. Hemp, by contrast, although it looks like marijuana and it smells like marijuana, it has a very low level of THC. The statute allows for the hemp to have no more than a 0.3% concentration of THC, and then it's legal. Anything above that would be deemed unlawful, illegal possession of marijuana. However, hemp, one can typically be assured that hemp is never going to exceed that 0.3% level. Hemp is used largely for rope, CBD oils, all the things that you see that are being sold today as CBD has risen in popularity. Although you can smoke hemp, you will not get high because it does not have enough THC within it to create that psychoactive high that you get when smoking marijuana. This has also created a problem with proving cases once they get to court. When a person is charged with marijuana possession, they can go all the way back to the original investigation, because so many marijuana possession charges have its origins in vehicle stops. It's important to take a look at what happens at the roadside. Officers will oftentimes allege in their probable cause affidavits that their probable cause for the search of a vehicle was based on a scent of marijuana. The problem is that now that hemp is legal and the accepted belief in the legal community is that hemp smell is very similar, if not the same, to marijuana, that ground for a search of the car is no longer valid. And officers is going to have to make a couple of additional steps. They are going to have to investigate by hoping that the person in the car will talk to them. You are not obligated to answer questions of a police officer. If an officer tells you that they smell marijuana and they'd like to search the car, you do not have to give them consent. If they ask you whether or not the substance laying in between the seat that they see in plain view, if they ask you whether or not that's marijuana or not, you do not have to answer that question. Because if they conduct a search without a warrant or without probable cause and then charge you, there is a great opportunity that there could be a successful legal challenge to that prosecution later in court. Now, DUI prosecutions based on marijuana involve different issues, and we'll be discussing that in a separate video as well. But it's important to understand that any level of marijuana possession, misdemeanor or felony, it's important to avoid a conviction because a criminal conviction would lie in either a misdemeanor or a felony, regardless of whether or not you do any jail time. So with that, I hope that you learn more about Florida's marijuana possession laws. To learn more, go to our website, knowbeforeyouBlow.com. Again, my name is Lee Lockett, reminding you to know your rights and know before you blow. If you have any questions about this issue with marijuana possession in Florida or any criminal defense matter, please give me a call at 904-858-9818. Thank you.